All right. Hi, everyone. Welcome to our webinar on new online child safety rules. Stay compliant and avoid risk. My name is Simon Reynolds. I'm one of the legal consultants here, senior legal solutions consultants at LegalVision. We are very lucky to be joined by my co-host, Harmanjot, or Hami, as we refer. And Hami is one of our senior associates within corporate and commercial. So yeah, really looking forward to what Hami has to talk about today. Great. So before we begin, just a couple of housekeeping items. First and foremost, you will receive a recording and slides of this meeting in your email after we wrap up. So just keep your eye out for that. If you do miss anything, you can always rewatch. Secondly, just submit your questions in the Q&A box, and we will get to them at the end of this webinar. So throughout the meeting, please don't hesitate to pop anything through, and we'll try and get to all the questions at the end. And just last but not least, we always really appreciate feedback. So please complete the feedback survey after the webinar and pop your details in. That would be fantastic. Awesome. So yeah, just to keep in mind, by viewing this webinar, you're eligible to receiving a complimentary consultation with LegalVision, just more specifically to discuss your business requirements, your needs, and how we can support your business moving forward. To claim that complimentary consultation, please just leave your contact information in the survey at the end. Or you can happily just jump on our website, have a little mooch through there, and put your details in that way. Just a name, surname, email address, contact number, just so we can get in contact with you. That would be perfect. Awesome. I'm going to pass to Hami just to go through our agenda, and we'll go from there.
Thanks, Simon. Hi, everyone. Thanks so much for joining us today. It's lovely to see you all here. So today we'll start by talking about a quick overview of the new rules. We'll then chat about the impact that the new child safety rules are having on business operations. We'll run through some practical steps to avoid penalties. We'll also talk about how the new child safety laws interact with the GDPR. And then we'll have some time for a bit of some last few tips and some Q&A at the end. So the Online Safety Act 2023 represents the most significant overhaul of online regulation in the UK. It's not just another piece of legislation. It actually creates binding legal duties on almost all businesses, and these binding legal duties are already being enforced. Some of the key provisions that the legislation introduces. Firstly, businesses now have a duty of care. So if your service is likely to be accessed by children, you have a legal duty to protect them. This is a hard legal requirement rather than some optional guidance, and all businesses now need to be putting in place practical steps to make sure that children are protected. And we'll run through shortly what some of those practical steps might look like. As a business, you must actively identify risks to children and take steps to mitigate them through specific obligations around risk assessments, safety measures, and reporting obligations as well. Depending on the type of business you operate, you may need systems to determine whether users are children, and then, if so, apply appropriate protections. This could range from simple age gates to sophisticated age verification technology. Businesses must also regularly assess what risks a service poses to child users and document the findings of that risk assessment. This is an ongoing obligation rather than a one-off exercise as well. There are also some new content monitoring obligations. So businesses must now prevent children from encountering illegal content that promotes harassing, stalking, controlling, or coercive behavior. You must have processes to stop children from accessing legal but harmful content, such as content that promotes suicide or self-harm. There's also reporting obligations where you find illegal content involving children, you must report it to authorities immediately. There's also some obligations around implementing complaints procedures. So businesses now need to provide processes that allow users to easily report content that is harmful to your children and implement complaints handling procedures. And those procedures need to be suitable for use by children. So they need to be easy enough that a child can log on and report a complaint should the need arise. Um, Businesses are required to have particular regard for protecting users' freedom of expression and privacy rights when implementing safety measures. So, although these obligations now exist, they don't exist in silo. They need to be treated in accordance with the obligations under the GDPR and your other obligations at law more generally. So, in addition to the new obligations on businesses, the Act also gives Ofcom greater enforcement powers. So Ofcom can require information about your services and your compliance with the Act and the relevant codes of conduct at any time. Sorry. If you're unable to provide this information when Ofcom asks for it, or if it reveals compliance failures, you'll face immediate enforcement action. So this enforcement action could include fines of the greater of £18 million or 10% of your global turnover. Ofcom can also block your service entirely in the UK by requiring internet providers to stop users from accessing your platform. So obviously they've clearly got some very large powers here to now take over control where you're not meeting your obligations under the legislation. And then most seriously, Ofcom can pursue criminal prosecutions against directors and senior managers for more serious breaches. So not all services are treated equally under the Act. However, the Act does cast a fairly wide net. Your obligations under the Act will depend on your classification, with the key affected parties being user-to-user services and search services. So user-to-user services are services where users can encounter content generated or uploaded by other users. This captures social media platforms, video and image sharing platforms, online gaming services with chat functions, dating services and apps, file sharing and cloud storage service, online marketplaces, or basically any website or app with comment sections, forums, or user messaging capabilities. Search services, on the other hand, are kind of your general search engines. So think your Google, your Bing, your Yahoo. It also includes platforms, larger platforms that have search functions such as directories or marketplaces or user directories. Every regulated provider must conduct a children's access assessment. The deadline to do this was April 2025. You must determine whether children can access your services and whether they're likely to do so. Ofcom guidance suggests that you can only conclude that children cannot access your service if you have highly effective age assurance measures in place. And we'll talk about what highly effective age assurance measures mean shortly. However, if you don't have those processes in place, then you're deemed it'll be deemed that your children can access your website, and then you must assess whether significant numbers of children use your service or whether your service is likely to attract them. You must record your assessment findings and evidence regardless of what those findings are, so that if Ofcom does come knocking, you've got some sort of record that you've gone through this process, you've made a decision, and your reasonings for making that decision. If children are likely to access your services, you must complete a children's risk assessment and implement relevant safety measures. And the safety measures that you implement will need to be proportionate to the risks that are posed by your service. The deadline to do this children's risk assessment was July 2025. Separately, all businesses must complete an illegal content risk assessment, the deadline for which was March 2025. And the purpose of this risk assessment is to understand the risk of users encountering illegal content and your service being used to commit crimes. Now, depending on the risks identified by your risk assessments, that will dictate what measures you are required to implement. Like I mentioned, your safety measures will always need to be proportionate to the risks identified in your risk assessments. To supplement the Online Safety Act, earlier this year, Ofcom published codes of conduct. They were released in July. The children protection codes were released in July this year, whilst the illegal content codes were released in February this year. There's also age assurance guidance that is now available. Each of these codes separately recommend practices and safety measures for compliance. If you don't implement recommended measures, so you can choose to implement your own measures that aren't the recommended practices. But if you do that, your alternative measures need to still ensure compliance, and you need to have a record of why you think those measures instead are still meeting your obligations. Implementing the recommended practices automatically deems you compliant with the freedom of expression and privacy duties that are also embedded within the legislation. And then the codes of practice actually suggest different measures based on your business type and perceived risk type. So it is quite a holistic code of practice that does make that is kind of applicable to everyone. It makes suggestions based on the type of business you run, the type of risk that you may have. So they're following those is kind of a surefire way of making sure that you're staying compliant. As we mentioned earlier, the deadlines to conduct the relevant risk assessments required by the Act have now passed. If you are a regulated service and you haven't already conducted the relevant risk assessments, I'd recommend you do so quite quickly. Prioritize these and put in place a plan to meet your obligations under the Act. Remember, the definition of a regulated service is broad and will capture even small businesses providing services where users can interact with each other or otherwise search for information. So I briefly mentioned highly effective age assurance measures a little bit earlier, and you're probably wondering what this means. If a service provider wishes to assess that their services are not possible to be accessed by children, they need to implement access controls to prevent children from accessing their services. This obligation to implement access controls also applies to service providers whose services allow pornography or adult content, including tube, cam, and fan sites. In order for access measures to be highly effective at correctly determining whether a user is a child or not, the measure must be technically accurate, robust, reliable, and fair. So what does this actually mean in practice? There's some examples that the code set out as methods that Ofcom consider capable of being highly effective. Some of these include verification through open banking, so accessing the information that a bank has on record regarding a user's age, obviously with the user's consent. This generally returns a yes or no result without sharing the user's date of birth or other information. You could also try photo ID matching. This captures relevant information from an uploaded photo ID and compares it to an image of the user at the point of the ID upload. So it's verifying that the user is who they're saying they are and therefore verifying their age. You could also use facial age estimation. This analyzes features of a user's face to estimate their age. You could try credit card checks. So in the UK, individuals must be aged over 18 to obtain a credit card. So the credit card check requires a user to input their credit card details, after which a payment processor sends a request to check that the card is valid by the issuing bank. And obviously, if the card is valid, then you would get a yes result, meaning that the user is over the age of 18. You can also use digital identity services. These are wallets that enable users to verify and securely store their attributes, such as their age, in a digital format, and use these as digital ID. So there's some measures that are considered highly effective and would allow you to meet your obligations under the legislation. But what do we not consider as capable of being highly effective? Firstly, self-declaration. So asking a user to input their date of birth without further evidence to confirm this information, or asking a user to confirm that they're over the age of 18 with a checkbox. Age verification through online payment methods that don't require a user to be over the age of 18. So, for example, debit cards do not require cardholders to be over 18, and so therefore they wouldn't be considered a highly effective age assurance measure. And then separately, general contractual restrictions on the use of the service by children. Simply having in your terms and conditions that users must be over the age of 18 is not sufficient to meet your obligations at law. So you've put in place highly effective age assurance measures if it applies to your business. What are some other practical steps that you can take to avoid penalties? Firstly, have a think about what safety measures you could implement to protect children that are on your app. So create systems to review suspected harmful content and implement swift takedown procedures for illegal or child harmful content, or use highly effective age assurance to block child access. You could also establish child-friendly user reporting mechanisms for illegal or harmful content. So having an easy-to-access reporting button that allows users to report content that they don't think is appropriate. You should, if you're a search service, you must also rank harmful content lower and blur any harmful images in your results than you would other content. If you know you've got users under the age of 18, apply a safety by design approach and include some of the highest privacy settings for those users. Make those your default settings. You can also think about implementing additional safeguards for risky features and undertakes regular safety testing in the development process. And then so that you're, staying on top of your processes and making sure that you are, that as time goes on, your processes are still working for you and your business. You could also exclude harmful content from children's feeds. So if you run a social media site, for example, cater their algorithm so that it removes any harmful content from their homepages. And then search services must also monitor and remove harmful autocomplete suggestions. So any autocomplete suggestions that refer to illegal content or legal content that could be harmful to children, such as content that promotes self-harm or suicide. You're also required to implement a complaints procedure, and we touched on this briefly earlier. Your complaints procedure should be simple and accessible, should be easy to find, access, and use. So this means that it needs to be accessible for both children and for adults. If you do receive a complaint, make sure you acknowledge it and provide an indicative response time so that your users know when they can expect to hear from you. And then make sure that you're handling any complaints and any appeals promptly and fairly. You should also update your terms of service and privacy policy on your website to make sure that they're drafted using language that is accessible to children, particularly where your service is one that is primarily accessed by children. In your terms of service and in your privacy policy, clearly signpost any child protection provisions and set out how you're making sure that you are meeting your obligations under this legislation. Think about your team and the role that they play in making sure that you're staying compliant with your obligations here. So engage with your team, appoint a senior individual accountable to your board and regulators for child safety compliance. Ensure that this senior individual can explain the decisions that the business has made and the risk management strategies, that have been implemented. And then also just generally for everyone else on your team, run some training. Ensure that they know what their obligations under the Act are and what their role is in supporting you to meet your obligations. What are some of the other things you can do? So there are fees being introduced. At the moment, these are not payable, but the Act does contain measures requiring regulated businesses to pay a fee to Ofcom. These fees will go towards funding Ofcom's regulatory activities. The fee will be payable by businesses who have a minimum qualifying worldwide revenue from regulated activities, being the user-to-user services or the search services. Ofcom has made recommendations to Parliament. However, the threshold amounts are still to be confirmed, as is the amount of the fees that will be payable. The current proposal would require businesses with an annual qualifying worldwide revenue from regulated activities of at least £250 million to pay fees. But like I said, this threshold is still under consideration, and Ofcom have indicated that any threshold between either 200 million to 500 million pounds is appropriate. So that's one of the obligations you should keep an eye on. Despite Ofcom's recommendations, the Secretary of State has the authority to determine that threshold and the amount of fees as they see fit. So although that guidance has been provided, it could very well land higher or lower than that. You should also regularly review your risk assessments to ensure that the level of risk that you are using to guide your compliance measures are still accurate. Complete regular audits and technical testing of your implemented measures to ensure they remain effective. And when you redo your risk assessments, make sure that you're redoing it based on any changes that have happened in your business as well. So if you've started a new service or added new features to your platform, make sure that you're then redoing your risk assessments at those points in time as well. Note that these practical tips are those that are intended to apply to all regulated service providers. Any service providers that are a large service or a multi-risk service may be required to implement additional measures that kind of go above and beyond some of the ones that we've talked about today. Some additional obligations on large or multi-risk services include additional resourcing to staff a child safety function within the business, the implementation of policies relating to content prioritization in children's feeds, additional complaints handling obligations and providing crisis prevention information for certain topical searches on search services, and then also just making sure that you're staying on top of the legislation generally and any changes that are happening there. So obviously the Online Safety Act and the relevant codes of conduct are imposing a lot of new obligations on businesses in respect of how they work with children. But how does this interact with the GDPR? Now, if you're putting in place, for example, highly effective age assurance measures, you're obviously collecting personal data. So you need to be thinking about what your obligations are under the GDPR. The regulators are clear that service providers are expected to take a data protection by design and by default approach to meeting their obligations under the Online Safety Act. This means that privacy considerations must be built into systems from the outset and not added as an afterthought. Compliance with the Online Safety Act does not exempt service providers from their obligations under the GDPR. Alongside the codes of practice released by Ofcom, the ICO has its own age-appropriate design code, otherwise known as the UK Children's Code, which contains recommendations for designing online platforms that include built-in protections for children. The ICO's age-appropriate design code and Ofcom's protection of children codes are fairly aligned and all serve the same purpose, which is the protection of children online, so they should be read in conjunction with each other. The UK Children's Code requires that service providers implement high privacy by design, meaning the design of their services must protect children's privacy. This code prohibits services provided from the detrimental use of children's data. This means that service providers must ensure that they are not using data in a way that is detrimental to children's physical or mental health and well-being, or that goes against the codes of practice or regulatory provisions. Detrimental uses of data could include profiling children to undertake behavioral advertising that exploits their inexperience or vulnerability. It also includes marketing inappropriate goods or services to children. The UK Children's Code also prohibits nudge techniques to weaken privacy. These could be visual nudge elements, such as large prominent yes buttons next to tiny or inconspicuous no buttons, or making low privacy options quick and easy to access, whilst high privacy features require multiple steps. Nudge techniques that lead children to provide unnecessary personal data encourage children to turn off privacy protections or lead children to lie about their age are specifically prohibited. Under the UK Children's Code, geolocation tracking options must be automatically switched off by default, and children must actively choose to enable location tracking. So any setting that makes a child's location visible to others must automatically revert to off at the end of each session, even if it's been turned on by that child for a particular session. And then finally, the Age Appropriate Design Code, or the UK Children's Code, also requires that service providers meet their transparency obligations under the GDPR in age-appropriate methods, such as providing bite-sized privacy information tailored to different age groups. And this goes back to what we were talking about earlier, about making sure that your privacy policy and your terms of service are drafted in language that is accessible to children. So specifically, how does age assurance and data processing kind of go hand in hand? So obviously, highly effective age assurance measures will require the processing of personal data. Businesses implementing such measures must have a lawful basis to rely on in order to collect and process that personal data. In addition to that, businesses must consider the best interests of the child when developing their age assurance measures and choosing which measures to put into place. You should also consider your data minimization obligations under the GDPR and only collect what information is absolutely necessary and only store any information that you absolutely necessarily need to store. Any personal data that is collected should be used for the limited purposes of conducting the age assurance verification and not for any other purpose. And if you are implementing highly effective age assurance, make sure that you're also conducting a data protection impact assessment to assess the data protection risks that might arise from such measures to make sure that you're putting in place appropriate measures from a GDPR perspective to meet your obligations there as well. So child safety isn't just about avoiding penalties. Obviously, the penalties are quite significant, but it's also about building a sustainable business. Now, particularly in this day and age, having a platform or a business or a service that is protecting children builds user trust. Parents are increasingly expecting robust child protection measures in place, and having such measures in place makes it easier for parents and users to trust your service. It also builds investor confidence. So if you're looking to expand your business by going out to VCs and other investors, they want to see that you are meeting your regulatory obligations and that they are investing into a business that is compliant and taking its regulatory compliance seriously. In addition to this, there are some markets and partnerships that require demonstrated safety credentials, and making sure that you're meeting your obligations here will make it easier for you to access those markets and those partnerships. And then finally, putting in place measures now helps you to future-proof your business. The regulations are only going to get stricter as more guidance comes out, as the legislation gets tighter, and early compliance here gives you an advantage. It allows you to make sure that you can just build on the measures you've already implemented rather than starting from scratch when new legislation is introduced. So as you can see, there is obviously a lot of benefit to putting in place the measures now, and hopefully This webinar has given you some ideas on some of the measures that you can put in place to make sure that you are meeting your obligations under the new child safety laws and that you're staying compliant and avoiding risk. I'll hand back over to Simon now, who'll run you through a couple of final admin points.
Amazing. Thank you so much, Hammy. That was incredibly informative. Yes, so that concludes the main part of our webinar. I hope you found it useful. As you can see, you might find our publication really useful. Obviously, you can jump on our website. We've got loads of resources there that you can download. Or as you can see, you can just scan the QR code and down the publication there. Loads of very useful information in that, so don't hesitate. Awesome. And then, yeah, you might be interested. I mean, we run these webinars pretty regularly now. So, yeah, you'll probably be interested in our next up and coming event. Please join us for our next webinar, which is going to be on attracting great talent to your startup. So, understanding EMI option plans. That's going to be on Tuesday, on the 14th of October at 11 o'clock. Obviously, you can see the link there. You can jump on our website too if you're wanting to register for any of our events moving forward. Great. So yeah, I just wanted to talk a little bit about the membership that we offer. Obviously, we're going to answer any questions very shortly while you submit them, just to talk through obviously how we support majority of our clients, which is through our membership model. So traditional law firms typically charge, per piece of work or on an hourly rate, as if you've worked with any lawyers in the past, that can add up really, really quickly. Here at LegalVision, we offer what's called a legal membership model, and it's really shaking up the legal world. It's literally a fixed monthly cost, and you're getting unlimited commercial legal support. So we're there to assist with unlimited advice consultations, document drafting, trademark support, intellectual property support, everything that you can think of that falls under the umbrella of commercial law. And we can help in more complex areas like mergers and acquisitions, disputes, litigation, as well as any sort of capital raising. So if you're interested, please don't hesitate to book in a consultation. As you're aware, you get a free complimentary consultation with us, just so we can discuss your specific needs. We do have different price points for the membership, depending on the business that you have and how established you are and what sector you're in. But yes, we would love to sit with you and discuss how we can support. There's a bit of a costing range on our website if you want to have a little nosy on that. But yes, our membership is a great way to get really cost-effective value for your business and as you continue to scale and grow. All right, so we're going to hand back over to Hammy just to answer, obviously, any questions. Whilst we do that, you'll see there's the poll question pop up. Would really appreciate if you could please answer it. So just to ask the question, I guess, is how are you currently managing your legal needs? I'm going to pass back to Hammy to go through some of the answers and discuss specifically some of your questions that you have. But that's the question. How are you currently managing your legal needs? Thanks, Hammy.
Thanks, Simon. So yeah, well, I'll go ahead and get started on some of the Q&A. While I'm doing that, if you could answer that poll, we'd really appreciate it. You'll notice a little Q&A box on your screen. We've had a few questions come in, but if you've got any more, please feel free to put them in there, and I'll do my best to get through as many as I can today. So this first one, does the new online child safety rules also affect medium to large scale organizations? Yes, definitely. And I'd argue that it's a bigger impact on the medium to large scale organizations than it is for small to medium businesses. As we mentioned, the safety measures that you are required to implement will be proportionate to the risk that you the risks that you identify. And arguably, medium to large scale organizations are likely to have greater risks when it comes to their services and their platforms being accessed by children. So if you are a medium to large scale organization that operates a user-to-user service or that operates a search service, then definitely the new legislation does impact your organization. Self-confirming age for age-restricted products and services is insufficient. How far do businesses need to go to verify age of consumers? That's a really good question, and that's kind of one that we have spoken about a little bit during this webinar. But I guess simply, as you've pointed out, having a self-declaration of age is not appropriate. So what you need to do will kind of depend on the type of business that you run, your operations, and the risks that you have identified. But at the crux of it, you need to satisfy yourself that if you are running a business related to an age restricted service, that your users are over the age of 18. So whether that be to implement some of those sort of methods that we've talked about, like the credit card verification, or the digital ID verification, the photo ID verification, whatever it may be, as a business, you need to be confident that where you are providing an age-restricted product, that your service cannot be accessed by children. Okay, we have a small e-commerce site with customer reviews. Does that really make us a regulated service? That's a really good question. And on face value, yes. So if users can interact with each other or interact with content that's posted by other users, we would consider that to fall within the ambit of the legislation, and you would be required to comply with that. Now, it really, again, you need to identify the risks within your business, and some of the measures that you implement are likely going to need to be less stringent than, say, a medium or large scale social media platform, where the whole purpose is for users to interact with each other. So although the risk for you is lower, you are still required to comply with the legislation, and there will still be measures that you need to implement in order to make sure that you're meeting your obligations there. So we've had some responses to the poll question. As a reminder, the question was, how are you currently managing your legal needs? And the options were in-house team, external provider, mix of in-house and external, not currently using legal support, or reviewing options. And most of our users seem to be using a mix of in-house and external. So that's great to see. Sorry, I'll hand back over to Simon now to wrap up.
Thanks so much, Hammy. And yeah, that's all the time that we have for today. Thank you so much for taking the time to join us. Sorry if we haven't got around to answering your specific question, but yeah, please submit your details in the survey at the end, obviously, to have some free complimentary sessions. We can obviously discuss your specific legal needs. A lot of our clients tend to find those meetings incredibly valuable. Obviously, we can answer any questions that maybe we didn't cover today, but we also would really appreciate if you could submit some feedback. Obviously, this is a free webinar, but if you could take 30 seconds to give some feedback, always really, really valuable. Outside of that, have a fantastic rest of the week and enjoy. It is getting a bit colder, so keep yourselves warm. And if you need anything else, please don't hesitate to jump on our website. Thanks so much. Take care. Bye-bye.
Thanks, everyone.